very much, Oliver, for providing such useful information about naturalization and registration application. We get asked a lot of questions regarding these applications, and I'm going to ask you some of the most frequently asked questions related to these applications. So a parent has contacted saying their child is under 18, and does he have to meet the English and Life in the UK test requirement to apply for British registration?
I can give a clear and good answer to this question. There is no English language requirement for British registration applications.
Perfect, good news. Another question is, I have had ILR, indefinite leave to remain, since I was a child and have schooled in the UK. Can I use my English GCSEs to meet the English language requirement?
I'm afraid you can't, no. You have to meet a requirement as published on the Home Office website. That would not include school exams of that kind, I'm afraid.
Okay, thank you. Moving on to our next question. It says, I'm ready to apply for naturalisation to become a British citizen. I wanted to know if I can use my postgraduate diploma, which I obtained in the UK, to meet the English language requirement.
To satisfy the English language requirement, yes, you can. You can now rely on qualifications of that type. But don't forget that the Life in the UK test is a different and separate requirement.
Great. So 2 different tests to do: English language requirement plus Life in the UK. Perfect.
Exactly.
Lovely. A gentleman has contacted saying, I cannot pass the Life in the UK test or the English language test. Can I ask for an extension? Can I ask for an exemption?
An extension
from
wouldn't
these? No. Great. So what about the exemption though?
Can you tell me, do you know what age he is?
He's mentioned he's 46 years old.
All right, well, he can't get an exemption because of age, because he'd have to be 65. He might be able to get an exemption on health grounds if he can show with proper medical evidence that his health condition prevents him from being able to pass those tests. Now, I think that's the only other way round.
Wow, that means he either need to meet the criteria set for exemption or try to pass the test and then make an application.
Well, to put it bluntly, he'll either have to try harder or work out whether he really could qualify for exemption on a basis of medical grounds. Now, if he thinks he might have medical grounds, he needs to approach his medical practitioner and ask if the medical practitioner would be prepared to certify that he wouldn't be able to succeed in the test because of his medical condition. If the medical practitioner can do that, then he could successfully apply for exemption.
Okay, great. A detailed answer. Thank you so much for that.
And may I say, I have actually done many cases where such applications were successful. Exemption has been granted, but you need a good letter from the medical practitioner.
Perfect. That's also really good to know. Practical experience always helps the applicants. Brilliant. So another question is a lady saying she has obtained indefinite leave to remain based on domestic violence route. She would like to find out, does she also need to pass English test and the Life in the UK test for her naturalisation application?
Yes, I'm afraid she does. Having acquired settlement by means of the domestic abuse route doesn't excuse the requirements when it comes to naturalisation application, I'm afraid.
All right. So although she probably might have been exempted on ILR stage, she's not exempted at a stage where she wants to become a British citizen.
Well, unless one of the exemption criteria apply to her, but it would be the same for her as it would be for anybody else.
True. Great. Another question we have is, my naturalisation application was refused, saying that I was not in the UK exactly 5 years ago on the date of my application when it was submitted. Have the Home Office made a mistake? Is this a real reason to refuse?
Well, the Home Office makes a lot of mistakes, but I think in this case they probably might not have done. That is a rule, and it's a published rule. On the date that the British Citizenship Application is received by the Home Office, you must have been in the UK 5 years before that very date. That is in the rules, I'm afraid.
Wow. I bet a lot of people don't know about
I
that.
think you're right, actually, especially if they are unrepresented, that they might have missed that rule, because it sounds a bit silly, but it is a rule.
Wow, great. Another question, please. It says, I have received my ILR based on the long residence 10 years route to settlement. Do I have to wait 1 year before I can apply for naturalisation? I am, however, married to a British citizen for over a year now.
All right. If you're married to a British citizen for any period, even 1 day, you don't have to have held settlement for any particular period of time when you make your British naturalisation application. It cannot be refused on that basis. As long as you hold settlement on the day that you make the application, then you can't be refused on that basis. I mean, you might always be refused on something else, but you can't be refused on that basis. So that person will be all right.
Brilliant. Good news. I have been absent from the UK for 705 days over the last 5 years due to family health problems. But I have been resident in the UK for 10 years. I also have a child who is a British citizen and goes to the school in the UK. Will my application be successful in this scenario?
Well, I can't guarantee that your application is going to be successful. However, the Home Office has got published, not exactly rules, but policies. Policies are additional to the rules. The Home Office policy says if you have absences from the UK for up to 730 days, which this person would, but you've been resident in the UK for at least 7 years, your application cannot be refused on that basis. Now, as I said, it might be refused on something else, but it can't be refused on that basis. This is a published Home Office policy, and it's in a legal way, it's a sort of a binding promise, and this client will be able to rely on that binding promise.
That's really good to hear. Perfect. And we've got a few other questions to go. One of them is related to parking tickets. Unfortunately, most of us end up getting one.
Only if you have a car.
Exactly, yes. And the question is, I have received 2 parking tickets, fixed penalty notices. Will this impact my naturalisation application?
I think probably not. Parking ticket is not a criminal conviction within general meaning or Home Office meaning. A few parking tickets, although you're strongly advised to declare all these sort of things when you make your application, but something like parking tickets is unlikely to fatally damage your application unless you run into some sort of other problem, such as you refuse to pay them and you get prosecuted. Then you're in big trouble. But parking tickets, fixed penalty notices by themselves are not likely to fatally impact on your British naturalisation application.
Okay.
And can I just throw in something else?
Yes.
County court judgments are not likely to impact fatally on your British naturalisation registration unless you've got too many of them.
Okay.
If you've got too many of them, this could affect the good character requirement.
All right, that's great. One of the questions was related to that, so that's cleared up as well. Brilliant. If a gentleman says he entered the UK illegally about 7 years ago, he has obtained ILR for about a year now. Can he apply for naturalisation? Just to clarify his marital status, he's single and is not married to a British citizen.
Well, I suppose anybody can apply for naturalisation, but the test is it a strong application? I would advise very strongly that this application is going to be refused, because as I was saying earlier, there's a 10-year. It's not a rule or a law, it's a policy that the Home Office will rely on. If you've got any bad character issues in the last 10 years, including breach of immigration rules, then that's going to impact severely on your application. Illegal entry is definitely a breach of something, criminal and probably immigration rules as well. So I would say that this person would be very, very poorly advised to make the application. They should wait maybe another 3 years until that 10-year period is passed, and if nothing bad has happened in the last 3 years, then they probably could make a strong application.
Great. Thank you so much for clarifying that. I think that's about it all. Thank you so much for providing such great and useful information once again. I'm sure our viewers will enjoy this vlog as they have enjoyed the previous ones. And we see you in the next vlog.
Yes, thank you very much indeed. It's been a pleasure.
Great. Bye-bye.
Bye-bye.